Good morning, everyone. Welcome to Polity of Class 3. Today we will be covering from next section, that is 4. I hope all of you have given the revisions and marked the entire important one. Okay. So today our first topic is center-state relation. So first, fiscal federalism. So first of all, you have to understand what is federalism and then fiscal. Okay, I hope federalism all of you know. So fiscal federalism is refers to how federal, state and local governments share funding and administrative responsibilities within India federal system. So फेडरल मतलब क्या है? फेडरल का मतलब है cordial relations among the states and within states or state and center. Okay. Constitutional provisions defining India's fiscal federalism arrangement. There is 7th schedule. Constitution delineates tax bases between Union and state, that is Article 246. So, if the question comes, mention the provisions which highlights the federal relations among the states and center, that is tax. Okay. Union may make rules, but ultimately the execution power depends on states. Okay. Next, distribution of revenue. A classification of tax revenues between union and state is as follows: tax levied and collected by the center but wholly assigned to the states. Okay. So next is levy and collection and GST in course of interstate trade and commerce, Article 269A, which is distributed between center and state on recommendation of GST Council. Next, tax levied and collected by union, corporation tax or personal income tax and central GST and distributed between union and state, that is Article 270. So ultimately Article 246, 269, 270 are all tax devolution. Okay, basis of devolution. So basis of devolution is two. One is vertical devolution and another is horizontal devolution. So vertical division is from center to state and horizontal division is among the states. So please remember what is vertical devolution and horizontal devolution. Okay. So as per 15th Finance Commission, the assigned criteria with their weights are income distance 45%, area 15%, population erosion 15%, demographic performance 12.5%, and forest and ecology 10%, and tax and fiscal efforts 2.5. So the shares of devolution of a horizontal devolution will depend on following these criteria. So please mark a star marks on these. The as per 15th Commission, the devolution will depends on income criteria, that is 45%, area 15%, population 15%, demographic performance 12.5%, forest and ecology. So what are those? One is income, another is area, and another is population. Next is demographic performance, forest and ecology, and tax and fiscal efforts. Next, grants in aid. Article 275, borrowings. So grants in aid is dependent on Article 275. Borrowings as per Article 270, Union government has power to borrow money either within or outside the country, whereas Article 290, the state government can borrow within India and not abroad. Okay. Next, status of state finance. So Finance Commission is constitutional backup, Article 280. Okay. Next, state finance only 58% of the revenue expenditures from their revenue sources. Debt to GDP ratio of states stands 27.5% March 2023. So debt to GDP ratio is 27.5%. Okay. Source of state revenue. These are some of the sources. Please go through. Okay. Next, special category of status. Special category status. So special category status was demanded by Bihar and Andhra Pradesh. See, remember this. This is now not in existence. It was early. Okay, but recently the Bihar and Andhra Pradesh government has demanded for special category status. Okay, I can or you can recall that the northeastern states, for example, Assam, Meghalaya, Tripura, Mizoram, all received some special category status. Okay, because in their case the entire funding is received from the center, for example any construction activities, any development activities, whereas in other states there is 60-40%. Okay, so I hope all of you have remembered. So okay, next, about special category status. Special category status is classification given by the center to assist in development of those states that face geographical and social economic disadvantages. It was introduced in 1960 on the recommendation of 5th Finance Commission. Next, in 19 Jammu and Kashmir, Assam, Nagaland were granted a special category status. So, in 1969, 3 states have been granted, that is Jammu and Kashmir, Assam, Nagaland. Later, Sikkim, Tripura were given status. Special category status states used to receive grants based on Gadgil-Mukherjee formula. Gadgil-Mukherjee formula. Constitution does not include any provisions for categorizations of any state in India as CSC states. Constitution does not include. Okay, it does not have any backup of constitution. Please remember, constitution does not provide any special category status. However, a wide range special provisions are available to as many states, for example 371, 371A, B, C, D, E, F, G, H, I, J, up to J. Okay, there are Karnataka, there are Goa, there are Sikkim, okay, Assam, Meghalaya, Tripura, Mizoram, Nagaland. Okay, so there are many other states which receives the special provisions. Okay, on the recommendation of the 14th Finance Commission, special category ceased to exist. So after 14th Finance Commission, the special category status has been abolished. Thus, no special category has been granted to any state. Current special funding better of Northeast and Himalayan states, etc., in account of the recommendation of subgroups of the Chief Minister are not as per special category status. No need. Next, criteria for special category status. So, what are the criteria for a state to become or to fall under special category status? Sorry. Hilly and difficult terrain, low population density, strategic locations, infrastructural backwardness, and non-viable nature of state finance. Special packages. Chief Minister of Bihar. Okay, these are please non-it. It is an additional grant under Article 282, which falls under miscellaneous financial provisions. Article 282, what is Article 282? Empowers the center and states to make any grant for any public purpose, even if it is not within the respective legislative competence. Now we are going to 6th schedule, the next topic, 6th schedule. I hope everyone remembers what is the difference between 5th schedule and 6th schedule. Okay, 5th schedule is scheduled areas and 6th schedule is tribal areas. Okay, so in 6th schedule only 4 states are there: Assam, Meghalaya, Tripura, Mizoram. Okay, so there is increased demand for inclusion of Ladakh in the 6th schedule. So recently the demand for inclusion of Ladakh in the 6th schedule area has been raised. So 6th schedule area under Article 244 under section 2 from Bardoloi committee recommendation. Which committee recommendation? Is Bardoloi committee recommendation. It empowers the governor to create autonomous district council and autonomous regional council. Autonomous district council consists of not more than 30 members, okay, among which 4 are nominated and 26 selected. Please remember, autonomous district council, that is 4 nominated and 26 elected. Okay, next, autonomous district council and autonomous regional council have power to make laws on subjects like forest management, agriculture, inheritance, marriage, and social customs, etc. They also have the power to collect land revenues, impose taxes, regulate trading, and collect royalties from the mineral extractions. Okay, if any kind such resource extractions is located within their area, then they have the power to collect land revenue and impose taxes and regulate trading and royalties. Okay, please remember. Next, difference between 5th and 6th schedule. So please remember, certain scheduled areas declared by the president in any state of India, currently in 10 states, whereas tribal areas comes under 6 scheduled area. I earlier told you these all are scheduled areas, where these are all tribal areas. Okay. Next, administrative body is Tribes Advisory Council, where this is autonomous. Sorry, ADC and ARC, Autonomous Regional Council and Autonomous District Council. Okay, whereas administrative body is Tribes Advisory Council. Next, Tribal Advisory Council, being the creations of legislative assembly of the state, has limited power, which are mostly executive. Extensive power including, okay, not applicable. PESA Act is applicable in 5th schedule areas, not in 6th schedule areas. Please remember, PESA is applicable in 5th schedule areas. Okay, next, formation of new states. So I hope everyone remembers Article 1 to Article 4 basically deals with states, union territories, okay, India as a union. Okay, so recently June to mark the 10 years for the formations of the Telangana state. Okay, procedure for formation of new state. Article 3, provisions for formation of new state and alteration of areas and boundaries or names of existing states. Power Parliament by law form a new state by separating territory from any state, uniting two or more states, uniting parts of state, and uniting any territory to a part of any state. Okay, next, it basically depends on the power of the parliament. Okay, presidential review. Such bill shall be introduced in either house of the parliament on a president's recommendation. So, on which recommendation the bill has been passed in the Lok Sabha or the parliament has been brought in the parliament to the Lok Sabha, it is on the basis of the recommendations of the president. Okay. Next, consultation of state legislature. Before recommending a bill which affects area boundaries of any state, the president shall refer this bill to the legislature of the state to express his views within a specified time. Parliament create a new state through ordinary legislation such simple majority formation of district. State government has the power to create new districts or alter abolish existing. Instead, changes can be made by passing an executive order allowing state assembly. So now here it is said that the recommendation of the state legislation will be taken into consideration only which state whose boundaries need to be altered. Okay, the state which or whose boundary need to be altered is the duty or is for the formality. The president takes the recommendations, if any, from those states. Okay, but it is not mandatory. But it is not mandatory to follow what they said. Okay. Next. Okay, and another thing, I hope all of you remembers Article 1 to Article 4. Any changes being brought in the state or union territories does not fall under any kind of amendment or does not consider as any. It is just considered as simple majority. Okay, no need of a special majority. It is passed through simple majority. Okay. So judicial pronouncement in related to reorganization of states are very union case. I hope everyone remembers. SK Third Commission, JVP Committee and Federal Commission, the first state reorganization commission. I hope all of you remembered. Very union case and SK Third Commission, JVP Committee and Federal Commissions. Okay. So when did Federal Commission was set up? 1953. Please remember the first state reorganization commission was set up in 1953. Next, moving to the 5. So the first topic is alternative dispute resolutions. I hope everyone remembers. It is ADR, alternative dispute resolutions. Okay. So recently Supreme Court has launched online mediation training web portal. So Supreme Court has launched an online mediation training web portal. It is developed collaboratively by the NALSA and Mediation and Conciliation Project Committee. So it has been developed by NALSA and Mediation and Conciliation Project Committee. Okay. MCPC was constituted by the Supreme Court of India in 2005. So Mediation and Conciliation Project Committee was also developed by the Supreme Court. It provides comprehensive training in mediation to legal professionals across the country and promotes alternative dispute resolution mechanisms. Okay. So online mediation training portal is in collaboration with NALSA and Mediations of Concern Project Committee, and mediation MCPC was constituted by Supreme Court of India. Please remember, and NALSA, I hope all of you know, it provides training to legal professionals. Okay, it provides training to legal professionals. So about alternative dispute resolutions, in which disputes are addressed and settled outside the courtroom. Okay, here the aggrieved parties or the parties involved no need to move to the court for dissolution. Okay. So types of RDR, there is 5 types of RDR. One is arbitrary, mediations, conciliation, and negotiation and collaborative law. Okay, I hope everyone has remembered or know plea bargaining. I hope everyone knows plea bargaining. Plea bargaining. If don't, then please go and have a look on this plea bargaining. Okay. Next is existing framework on arbitration. Existing framework on arbitration. So domestic arbitration, conciliation, and New Delhi International Arbitration Center Act 2019, Indian Council of Arbitration. So these are some domestic, and global is International Court of Arbitration, Permanent Court of Arbitration, Unilateral Model Law. So these are some of the global ADR. Okay, now next, Mediation Act 2023. President of India granted assent to pass Mediation Act 2023, seeking to promote mediation as a preferred mode of ADR in India. Key highlights of the Mediation Act 2023 is defines mediation. It includes expression mediation and pre-litigation mediation, online mediation, and community mediation. So any kind of mediation involved are comes under the definition of mediation. Okay, where parties attempt to reach an amicable settlement of their disputes without existence of the third person, referred to as mediator. Now, next, voluntary pre-litigation mediation is parties can attempt to settle civil or commercial disputes by mediation before approaching any court or tribunal. So, this is all about pre-litigation mediation. Means before going to the court, we resolved among us. So, this is pre-litigation mediation. Disputes not fit for mediation. So, what are the disputes which is not fit for mediation? Like relating to claims against minor or person of unsound mind, unsolved criminal prosecution, involving criminal prosecutions affecting the rights of third parties. So these are not valid for mediation or ADR. Okay. Territorial jurisdictions is mediation takes place within territorial jurisdiction of court or tribunal or competent jurisdiction unless the parties agree otherwise or undertake mediation online mode. Normally, it is within the territorial jurisdiction, but if the parties involved or the parties agree to go through online, then they may. Okay. Next, timeline is must be completed within 120 days. Please remember, must be completed within 120 days and extended by another 60 days. So on and around, you get 6 months. On and around, you get 6 months maximum and minimum within 120 days, that is 4 months. Minimum is 4 months and maximum is 6 months. Next, establishment of mediation council. Please go through. Next is Lok Adalat. Supreme Court organized special Lok Adalat on 75th year of its establishment for dispute settlement. About Lok Adalat. Lok Adalat is one of the alternative dispute redressal mechanisms. Okay, it has statutory status under Legal Service Authorities Act 1987. Okay, Act was amended and established permanent local justice for public utility service, which is guided by the principle of natural justice. Please remember, it works with the principles of natural justice. Okay, it doesn't look for evidence, but rather it works on the basis of natural justice. They are not bound by Code of Civil Procedure 1908 and Bharatiya Shakhya Adhinayan. It has the same power as civil courts under CRPC 1908. Decision made by the Lok Adalat is final and binding, and no appeal can be made against decisions. Yes, since their decision is final and binding, but one exception is if the decision has been obtained in an arbitrary manner or have some bias, then Supreme Court have the right to interfere in these regards. Okay, so please remember, this is exceptional case. Okay. Cases referred to Lok Adalat includes any case pending before any court, any dispute which has not been brought before any court and is likely to be filed before court. Okay. Nature of cases undertaken like matrimonial disputes, property disputes, motor accident claims, land acquisition, etc. Okay. First Lok Adalat is in Gujarat, Junagadh. Okay. Next, free legal aid. Okay. Now, if free legal aid, so please remember what are the articles that are associated with free legal aid. Which are the articles that are associated with free legal aid? One is Directive Principles of State Policy Article 39A, which briefs free legal aid. And another is Article 21, right to life, right to property, right to privacy. These are some of the rights. So, about free legal aid, it refers to the provisions of free legal service to individuals who are unable to afford legal representation and access to judicial systems. Legal aid can include legal advice, representation in court proceedings, mediations, negotiations, and alternate dispute resolution mechanisms. So, what are the concepts relating to legal aid? Article 21. No person shall be deprived of his or life or personal liberty except according to the procedure established by law. So, there is also some exceptions. Procedure established by law. I hope everyone remembers in Maneka Gandhi case, Neke Gopalan case. Article 39A ensures justice are not denied to any citizen because of economic and other disabilities. So this has been brought, Article 39 has been brought under with the help of Amendment 42nd Amendment Act. Okay. Statutory provisions for legal aid. Legal Service Authorities Act 1987 to constitute legal service authorities to provide free and competent legal service to weaker sections of the society. NALSA, National Legal Service Authority, or State Legal Service Authority and District Legal Service Authority were accordingly constituted. Bharatiya Nagarik Suraksha Sanhita which has been brought legal aid to accused at state expense in certain case where accused lacks the means of legal engagement. So Bharatiya Nagarik Suraksha Sanhita, okay, and another is NALSA, SLSA, SALSA, and DIALSA, okay, District, National, and State Legal Service Authority. So government steps taken for legal aid, some of the steps like Disha scheme, Telelaw, Nyay Mitra program, and Lok Adalat. Please remember, this will be very helpful for your mains answer writing. Okay, next. Eligibility for free legal aid. So who are the persons who are eligible? First of all, women and children, industrial workmen, mentally ill or otherwise disabled person, victim of traffickings, okay, persons whose annual income is less than or prescribed state of the government in the case before court than Supreme Court and less than rupees 5 lakhs. Next, members of scheduled caste and scheduled tribes, victims of mass disasters, and juvenile home. Okay, next, tribunal system in India. So I hope everyone remembers. It falls under Article 323 and 323B. Both are associated with tribunals. One is associated with administrative and another is, I hope everyone knows. So these are some quasi judicial bodies. Okay, both of them have constitutional backup. So Allahabad High Court held an appeal against an order of Central Administrative Tribunal while exercising contempt jurisdiction under Administrative Tribunal lies before Supreme Court and not the High Courts. So objective to reduce caseload. So what are the main objectives of setting up the administrative tribunal? To reduce the caseload before High Court or Supreme Court or any other courts. Constitutional recognition is Article 323 and 323B. Okay. Please understand the differences between Article 323 and 323B. Okay. One is administrative and another is please have a look on those Article 323 and 323B. This is some important and very easy one. Okay. So 323A is administrative tribunal, whereas 323B is others. For example, like taxation, land reforms, etc. You can also have a look on this. See here it is mentioned that 42nd Amendment Constitution Amendment Act by adding 323A for administrative tribunal and 323B for other matters like taxation and land reforms. Okay. These tribunal systems, appeals from tribunal usually lies with concerned High Court. Okay. So from tribunal it does not lies among district courts or any other subordinate courts, but it actually lies with the High Court, and from High Court it will lie, the appeal will lie before Supreme Court. Okay. The tribunals are set up on the recommendations of sentencing committee, purpose to resolve disputes and complaints on specific matters. Procedural complaints by principle of natural justice, a mix of judicial expert with special knowledge and limited of laws under which they are set. Next, bail. I hope everyone knows about the concept or about the words bail. So recently a case has been put up or came in front of Supreme Court, like Jalaluddin Khan and Environment case. Bail is the rule, jail is the exception. So this is the most important terms. Bail is the rule and jail is the exception. So actually what it means is that jail is to be granted only in exceptional situations when the law decides that the candidate need to be punished, and if in exception, if he is minor or some minor punishments or some punishment can be considered, then at that situation bail can be granted. So this is the main objectives. Now see, court observes that denying bail in deserving cases is violation of rights under Article 21. So many times bail is not granted, okay, due to various reasons. So now it is said that denying bail in deserving cases. So many cases are there which might be some, or which might not be so much strong, or might not become under some sort of serious criminal cases. So in this case, the bail can be granted, and denying all this bail is the violation of Article 21, right to life and personal liberty. So legal provisions of bail. Bail is bailable offences. Bharatiya Nagarik Suraksha Samhita (BNSS). Maximum period for which under trial prisoner can be detained is 1 half of the maximum period of the imprisonment. First time offenders will be given bail if detained for over 1/3 of the maximum period of imprisonment. So first time offenders can be granted bail only when he has remained in jail for 1/3 of the maximum period of imprisonment. Okay, maximum. For example, 40 years of jail. So 1/3 of 40, yeah, 30 years of jail. So 1/3 is 10. Okay, so if he is in jail for 10 years, then he may be granted for bail. Okay, first time offenders. Special laws such as POSCO and protection of women, etc., also contribute related to grant of bail. In this case, also bail is granted. Okay, next. So bail are of four types. One is regular bail, one is anticipatory bail, and interim bail and default bail. So what is a regular bail? So please have a read on this. Might come. So regular bail granted to a person already arrested and in police custody. What is interim bail? Temporary bail is granted before hearing for regular or anticipatory bail. So before anticipatory bail, a bail is granted, and that bail is termed as interim bail. So what is anticipatory bail? Anticipatory bail, precautionary bail is granted before arrest for a non-bailable offense. For example, suppose you have heard that an arrest warrant has been issued against you. Okay, so before the police come and catch you, you have applied for a bail. Okay, so that bail is termed as anticipatory bail. Okay. Next is default bail, granted when police fail to file a charge sheet within a prescribed period. So if the police fails to file a charge sheet against you after being arrested, then a default bail is passed. Okay, next, measures taken for bail. Plea bargaining enables a free trial negotiation between defendant and the prosecutions. In Section 290 of the Bharatiya Nagari Suraksha Sanhita, plea bargaining has been made a time-bound and application can be made within 30 days from the date of framing a charge. So under BNSS, the time frame has been issued, that is 30 days from the date of framing of charge. Applies only to offences punishable up to 7 years. So see, only is mentioned. Please remember, don't do mistakes in this. Here it is mentioned only. And the case or the jail period must be, or of a punishable period must be 7 years of imprisonment. Next is e-prison software. E-prison software is that you will not be in a jail, but every information about you will be there in the government software. Okay. Next is other important news. For example, Gram Nyalay. I hope everyone knows Gram Nyalay. It is in the panchayat level. Okay. So Gram Nyalay, the purpose ensures the opportunity for seeking justice are not denied to any citizens by reason of social, economic, or other disabilities. Statutory making under Gram Nyalay's Act. So Gram Nyalay has been set up under Gram Nyalay's Act 2008. The states which comes under Gram Nyalay are Nagaland, Arunachal Pradesh, Sikkim, and tribal areas specified in the Act. So mainly Nagaland, Arunachal Pradesh, and Sikkim. Seat of Gram Nyalay. Located at the headquarters of the intermediate panchayat status, Gram Nyalayas are deemed to be court of judicial magistrate of first class. So Gram Nyalayas, the main court of the judicial member is a court of judicial magistrate of first class. Okay. The person who is appointed as a magistrate in the Gram Nyalaya is termed as Nyayadhikari. Okay. Jurisdiction shall be a mobile court or in both civil and criminal jurisdiction. Okay, so both civil and criminal cases can be dealt, and these are specifically mobile court. They can move around. Okay. Next is dispute process. Dispute process are to be settled with the help of conciliation between the parties. These are not bound by rules of evidence provided in the and by the principle of natural justice. So I hope in the recent one we have seen tribunal depends on natural justice. So it is also dispute process. Gram Nyalaya also depends on principle of natural justice and not bound by rules of evidence. Okay. Appeal in criminal cases lie to the court of session and civil cases lie to the district court and shall be disposed within 6 months from the date of filing. So appeal from Gram Nyalaya depends on district courts. Okay. Munsif or next is contempt of court. So contempt of court means if anyone willingly disobeys the order given by the court. Okay. So, alleged delay in appointment of the Chief Justice of the High Court. Jharkhand government has filed a contempt petition against Center alleging delay in appointment of the Chief Justice of the High Court. So, about contempt of court, Article 129 to Article 25 give powers to Supreme Court and High Court to punish contempt. So, two types of contempt: civil contempt and criminal contempt. So, civil contempt will have willful disobedience to any judgment, decree, or declarations, order, writ, or other process of court, or willful. Okay. Criminal contempt is scandalize or lowers the authority of any court, prejudice or interferes with the due course of any judicial proceedings, interferes with or obstructs administration of justice. So see, this contempt, the decision of contempt basically depends on the, or it might create a situation of biasness. Okay, which comes under civil contempt or which comes under criminal contempt. So there is no such specific definitions of what is civil contempt and what is criminal contempt. Okay, so please have a look on this. Next is mercy petitions. President has rejected the mercy petitions of the Lashkar-e-Taiba terrorist sentenced to death for the December 2000 Redford attack. So I hope everyone remembers Article 22 read powers empowers the president to pardon, reprieve, and respite and respond or commute the sentence. Okay, so this the president has also a power to grant pardon and respite in case of the court martial or for any offense against any law related to the matter which execution power of the union extends or a sentence to death. Okay, next is curate petition. It is a last constitutional remedy available to a person whose review petition article 136 has been dismissed by the Supreme Court. Security petition is filed in the last situation. Okay, when there is no such way for a candidate. Okay, next given shape Rupak Ashok Arora and Ashok Arora and NR. Curative power of the court flows Article 142 power to complete justice. Power to complete justice is 142. Okay. Next, violation of principle of natural justice. Judge failed to disclose his connections to the subject matter. Next, fast track special court. The fast track special courts are much more efficient in handling rape cases and those related to the protection of children from sexual offences POSCO Act, according to the report released by Indian Child Protection. So, fast track special court is a centrally sponsored scheme launched in 2019. So it bears expenditure from Nirbhaya Fund. Please remember Nirbhaya Fund. Okay. Implementation is by Department of Justice and Ministry of Law and Justice. Fast track special court are linked to National Judicial Data Grid. Okay. Next, zero FIR. Zero FIR case against a former minister for. Acha, what is zero FIR? Please understand zero FIR. Zero FIR is a situation when the person, without going to the police station, files an FIR through the help of online platform of mobile. So in that case, zero FIR is registered. And next, the comes the FIR to be filed by the police in their register. Okay, so zero FIR is recent most because the time when the crime has been committed, you might not be able to reach the police station. So at that time, how can you file FIR? So through the help of mobile phone. Okay, this is zero FIR. Doctrine of coercion. So what is doctrine of coercion? Legal doctrine under English common law that places a married woman under the cover of her husband, treating them as a single entity. So under doctrine of coercion, the woman that has been married to a man will be treated as a single entity and under the name and fame of her husband. It suspends the very being of legal existence of a woman after a marriage. In theory, it seeks to pass on the property to the husband, restricting her ability to hold property and enter into a contract. Okay. Next, doctrine of harmonious constructions. I hope everyone remember. Harmonious construction is that if any law, see, the utmost decisions or the utmost ability of the Supreme Court will always try to keep all the law intact without harming each other. Okay. If see the some laws interface to other law, only then some amendment can be made or some changes can be. So about doctrine, it means that case of conflict between two laws, the interpretation should be in a way in which spirit and essence of both laws are maintained, which is done by harmonizing law. It originally is traced back to First Amendment made in judgment Shankari Prasad versus Union of India. Please remember. Next, important legislature bills. Bharatiya Nyaya Sanhita. I hope everyone remembers Bharatiya Nyaya Sanhita. It has been in news for many times. Okay, after it replaces Indian Penal Code. Okay, Bharatiya Nyaya Sanhita. It replaces Indian Penal Code. I'm not going through Bharatiya Nagarik Suraksha Samhita. It replaced Criminal Procedure Code. Next is Bharatiya Shaikya Adhyan, Indian Evidence Act. Digital Potential Data Protection Act. The President of India recently granted an assent to the Digital Personal Data Protection Bill. It aims to regulate the processing of digital personal data while ensuring individual rights to protect their data. So, obligation of data fiduciaries, rights and duties of data principles. What is fiduciary? So, please remember a person who holds asset in trust for a beneficiary. Okay, so original obligation of data fiduciary means the company might be thinking, for example, they say Airtel has many informations related to us, personal information. So in this situation, he is a fiduciary. Okay, so it is his rights such that our privacy is maintained. Okay, next, Data Protection Board of India has been set up. Appeals against its decision lies with the Telecom Dispute Settlement and Appellate Tribunal. Okay, wait a minute. So, Data Protection Board of India, the board, there will be two board members, and they are eligible for reappointment, and appeal against each decisions will lie with Telecom Dispute Settlement and Appellate Tribunal. Okay. Rights and duties of data principal: obtain information, seek corrections, and raise a grievance, redressal, and right to nominate a person to exercise rights. Violation of duties will be punishable with a penalty of ₹10,000. Okay. Next is exemptions for notified agencies for research. Okay, these are no need of public examination and prevention of unfair means. This has been in news for many times in the recent because of some fraudulent activities that has been carried out in the government public exam. So provides for venue in charge takes appropriate, including filing of FIR, periodic reporting of all incidents of the unfair means or offence in conduct of public to public examination authority by regional officer along with the details of actions taken. So these are non-bailable. Police can arrest without a warrant. Okay, cognizable means police can arrest without a warrant. Non-bailable and non-compoundable. Non-compoundable matlab compromise between the victims and accused is not allowed. Okay, non-compoundable. Next is Public Examination Not Telecommunication Act. It aims to amend a law. It aims to amend a law relating to development and expansions of operation of telecommunication service and telecommunication network, and is guided by the principle of inclusion, security, growth, and responsiveness. It repeals Indian Telegraph Act 1885 and Indian Wireless Telegraph Act 1933, owing to huge technical advancement in telecom sector and technologies. Assignment of spectrum. Spectrum allocation will be through auction. Okay, what does spectrum mean? So you have understood about 2G, 3G, 4G, 5G. So these are all some kind of spectrums that has been sold to the company, or the company acquires license on the basis of auction. Okay. Next is expand scope of Universal Service Obligation Fund. It will now become Digital Bharat Niti. So please remember, Universal Service Obligation Fund will be converted to Digital Bharat Niti under the control of central government. Next is internet shutdowns. Yes, it is often in our country. India recorded 16 internet shutdowns and the lowest in 8 years. Okay. Next is Consumer Protection Act. Supreme Court overruled National Consumer Dispute Redressal Commission judgment, which ruled service rendered by lawyers are covered under CPA 1986. Key features are broadened definition of consumer, included person who buy or avail of goods and services online through electronic means. So they have given definition. Okay. So definition of consumer includes who buy or avail goods and services online through goods or services online through electronic means. It does not include who obtain such goods for resale or for any commercial purposes. Okay, if you are a wholesaler, then you will not come under the consumer. For example, you have acquired a goods and for the purpose of resale, so you will not be included in the definition of consumer. Okay. Establish Central Consumer Protection Authority, stream dispute redressal mechanisms, consumer mediation cell established by central and state government, so to settle the disputes if any. Next, Consumer rights under Consumer Act 2019: right to safety, right to be informed, right to choose, right to be heard, right to seek redressal, and right to consumer awareness. 6. Consumer rights under Consumer Act 2019. Please remember: right to safety, right to be informed, right to choose, right to be heard, right to seek redressal, and right to consumer awareness. Next is Foreign Contribution Regulation Act. So recently, Ministry of Home Affairs listed the diversion of foreign funds for carrying out anti-development activities for inciting malicious protests and religious conversions to deny or cancel FCR. So Foreign Contribution Regulation Act. So recently, Ministry of Home Affairs has imposed some rules and regulations for unauthorized transfer of payments. Okay. So foreign contribution means donation delivered to transfer made by any foreign source of any article. Foreign contribution regulation is implemented by Ministry of Home Affairs. So please remember, Foreign Contribution Regulation Act is implemented by Home Minister. And supported by Intelligence Bureau. Okay. Next is foreign funds designated for an validity of FCR registration 5 years, and NGO are expected to apply for renewal within 6 months from the date of expiry. Okay. Next is submission of annual reports. So this is compulsory filing of annual reports. In case of any contravention or comment, can use restricted uses and utilize foreign condition after an inquiry. Post Office Act. So recently the Post Office Act that is changed by changing the Post Office Act 1998. What is that? Director General of Post Office will be appointed to head India Post. So now the new position has been created, that is Director General of Postal Service will be appointed to head the India Post. Power to intercept postal articles. Government can intercept an article transmitted to India Post on specified grounds. Okay, now what is this? So this is just a violation of our privacy. If we are sending some letters or some instruments to the postal service, then the government is saying the government has the power, or the Director General of Postal Service has the power to look into it if some suspicion arises. Exemption from liability. Post Office will not incur any liability with regard to its service except such liability as may be prescribed with regard to the service provided with the post service. There will be no penal provisions prescribed in the Act. So postal during British era, the first post office was opened on 1727. So you can remember 1757, 1727, 30 years before post office. Okay, 1727. Lord Dalhousie recognized the Indian Post Office as separate organizations of national importance, and present site of the General Post Office Kolkata was the site of first Fort William. So Lord Dalhousie, and post office, first post office is 1727. So we are ending the video here. Okay, and we'll be continuing in the next session from 7. Okay, then the first topic will be important constitution, statutory and executive bodies in news. Okay, thank you for being with me and understanding. I hope all of you have understood and underlined the important section. Okay, so please do come with preparation slightly so that you can have a better understanding of those. Okay, so thank you, bye bye, and before going, please subscribe and share the channel. Okay, and if any problem, please mention it in the comment section. Thank you and bye bye.